The Toyota case was a class action on behalf of anyone who bought a Toyota vehicle from 2002 to 2010. About 20 million cars. That's the largest automobile class action, we think, in the history of U.S. jurisprudence.
The cases grew out of reported incidents of unintended acceleration in Toyota cars that actually affected many models of Toyota vehicles.
From 2004, Toyota was aware of complaints of these sudden acceleration events from consumers. And they kept a database, and they knew about that. And it continued to mount, and their engineers couldn't come up with any answers.
And they hid the problem. They hid them from themselves in many ways. They hid it from the federal regulators.
Well, Toyota insisted very vociferously that if there was a problem, it was due to driver error.
And that's when they came up with the excuse that this was sticky pedals and floor mats.
There was probably 450,000 unintended accelerations in cars that weren't part of the pedal or mat recall. So there had to be something else wrong, and that Toyota wasn't telling the truth. NASA did a pretty exhaustive review of Toyota software and came out with the conclusion that they couldn't find any software errors that would cause unintended acceleration.
Well, the first step was to get access to Toyota's source code, which was a project in and of itself, because the source code was treated as if it were a military secret. So we had to have a safe room.
And there were only 3 lawyers allowed in the room from our side, and our experts.
They found what they believed were deficiencies in the source code, and that was the basis of our contention. On the legal front was a contention that Toyota made that only persons who actually had experienced a manifestation of the defect, that is, lived through an unintended acceleration event, would have standing to sue.
And what we had to do is convince the court that in this particular instance, when you have a safety-related defect, you don't have to wait for the harm to happen before you recognize that there is an economic loss to the consumer in having a car that is not as safe as advertised.
I would hope that the wider impact of the settlement we achieved in the Toyota case will be that manufacturers, and in particular automobile manufacturers, will have a greater sense of urgency in dealing with safety problems.
You can make a real difference in one of these class actions because you can force a company to make their car safer. And, as a plaintiff's lawyer, that's right to the heart of what you want to do, right?